Hello, hello. Today we're talking about the Supreme Court decision, U.S. v. Virginia, where the all-male admissions policy of the Virginia Military Institute was struck down as violative of the 14th Amendment's Equal Protection Clause. In this video, we're going to take a look at the majority opinion written by Ruth Bader Ginsburg and the sole dissenting opinion written by Justice Antonin Scalia. Okay, let's get started. After fighting for gender equality for most of her career and arguing before the Supreme Court several times, Justice Ginsburg gets to pen the decision in U.S. v. Virginia, which must have felt phenomenal. It was a 7-1 verdict in favor of the government, striking VMI's all-male admissions policy and signaling a massive victory for women's rights. In many ways, this decision was a definitive codification of Ginsburg's career-long advocacy for women's equality into American jurisprudence. And we need to pause here and really recognize what this means. Eyes may be the window to the soul for in-person interactions, but words are a window to the mind. When a writer has found their voice, their words offer an unparalleled glimpse into their thought process, their beliefs, their values, their dreams, and their fears. Every Supreme Court justice has a developed voice, a particular way that they like to present the facts or, make arguments that is unique to them. Because of this, I've often found that reading a Supreme Court decision feels like watching a very intimate performance. I say performance, of course, because these decisions are all made public. They're read from the bench and subsequently published. Why am I bringing this up? Because recognizing the slant that justices bring to their opinions is really helpful in understanding how their opinions are constructed and also helps us to sift through the arguments that they're making. Part of the reason why I think this case feels to me so impactful and so powerful is that in comparing the majority and the dissenting opinions, it really feels as though I'm reading a case study on how social advocacy for the expanding rights and liberties of a marginalized group butts up against the powers that be, who seek to continue to exclude those same marginalized groups from opportunities that were previously undoubtedly and unquestionably reserved for the majority. The slant that Justice Ginsburg takes here is undeniably one that advocates for change, that expands the liberties of a particular group of people, in this case, women. Conversely, in Justice Scalia's dissent, there is a slant taken that is very much advocating for the preservation of the status quo. Scalia's opinion strikes me as the mode of thinking that says equality is a zero-sum game, like a pie, where if I, as a man, want to give you, as a woman, a greater slice of the pie, then it means that I, as a man, have to give up some privileges that I've exclusively enjoyed. This to me seems in contrast with Ginsburg's opinion, which reads as a mode of thinking that says equality is not a zero-sum game. It isn't about who can consume the most of a finite resource. You don't need to ration equality because as a concept, equality isn't something that you run out of, like how you would run out of wine or other essential groceries. Instead, equality is a tool that we can use to craft our society into the meritocracy that we aspire it to be. Because when everyone has the same power, the same voice represented in politics, the same access to opportunities, the same access to advancement, the same access to education, the same stature in private and public spheres, then what we are left to judge people on is their own capabilities, is their own merits. And I understand this is all high-level theory I'm tossing at you guys. This is the most abstract that we're going to get this video. Landmark Supreme Court decisions often have a way of capturing different viewpoints in moments of change that reflect more than just the opinions of the individual justices that wrote those decisions. The same is true for U.S. v. Virginia. In order to highlight what I just said in a bit more of a concrete way, this video is going to present side-by-side comparisons of important points in the majority and dissenting opinion. So without further ado, Part 1, Issues Presented and the Appropriate Judicial Scrutiny to Apply. Justice Ginsburg frames her decision with two legal issues. One, Does Virginia's wholesale exclusion of women who want to be trained according to VMI's adversative model and who are able to meet VMI's entrance requirements violate the 14th Amendment's Equal Protection Clause? And two, if VMI's unique status in Virginia's educational landscape offends the Constitution, what is the appropriate remedy? We begin, as Justice Ginsburg does, by restating the requirement that sex-based classifications must be reviewed under intermediate scrutiny. And Justice Ginsburg cites Mississippi University for Women v. Hogan, which I talked about more at length in my last video, but to give a quick recap. In Hogan, decided in 1982, the Supreme Court struck down Mississippi University for Women's all-female admissions policy, stating that the single-sex policy was driven by stereotypes that nursing was an exclusively female profession and that men could not constitutionally be excluded from studying nursing. That case reaffirmed that the appropriate standard of review for sex-based classifications, including admissions policies of higher education institutions, was in fact intermediate scrutiny. Intermediate scrutiny, of course, means that the method chosen must be substantially related to the important governmental objective it seeks to achieve. Hogan, however, left open the possibility that a gendered law in the right circumstances could survive intermediate scrutiny. This brought to mind a different case, Kahn v. Shevin, decided in 1974, that held that a particular gendered statute, in this case a property tax exemption for widows and not widowers, was constitutional because it was based in affirmative action for gender and purported to help ease the burden of past societal discrimination against women. And this is what brings us back to U.S. v. Virginia. While Ginsburg does bring up the standard, she cites Hogan, she is also kind of all over the place in her discussion on scrutiny, and Scalia criticizes her for this. We'll get to him in a second. It seems to me that Ginsburg has a three-step analysis for how exactly intermediate scrutiny should be applied to sex-based classifications. And to be clear, this particular three-step process isn't laid out in the decision. This is me, after parsing this decision, trying to put the pieces together to present it in a cohesive way to you. Step one of the analysis. Does the government explicitly state what objectives they seek to achieve by either enacting or allowing a sex-based classification, and are those stated objectives pretextual? This is the court asking, hey, government, seriously though, why'd you do what you did? And this is important because the court isn't going to necessarily take at face value what the government proffers as its explanation. Here's what Ginsburg writes. The justification of the objective must be genuine, not hypothetical or invented post hoc in response to litigation, and it must not rely on overbroad generalizations about the different talents, capacities, or preferences of males and females. Now, this first part is basically saying that pretext is a no-go. Governmental objectives must be intentional from the jump. The government is not allowed to say, and for my next trick, this actually means X. The second part is where things get spicy. Not only can the stated objective not be pretextual, but it also can't be intentionally rooted in gender stereotypes. We're going to get back to this in just a second. Step two. Is the way that sex-based classifications deployed substantially related to the achievement of these stated important governmental objectives? In other words, is the means somewhat tailored to achieve the ends? Is having this sex-based classification going to do what the government says it's supposed to do? Step three. Was this sex-based classification designed as an affirmative remedy to compensate women for particular economic disability suffered or promote equal employment opportunity or otherwise help women? This is the yeah, but argument, a kind of exception, as it were. Yeah, this is an intentionally gendered statute, but it's doing good work, so we're gonna keep it. It is up to the states to meet the burden of intermediate scrutiny. In other words, it's up to the government to say, here's our thought process, and here's how we try to make those thoughts into a reality, and would you look at that, they match. Let's return to the aforementioned spiciness of Ginsburg's rhetoric. Here are the three steps again. This looks very logical. It's tabulated, it appears to be sequential. How lovely, but is it? Where does step 3 actually fit in? If the government objective is to create an intentionally gendered law to affirmatively remedy past discrimination, is the government able to write a law that is not based in some part on stereotypes and assumptions? There is an inherent assumption underlying laws that purport to remedy past discrimination, namely that that group actually experienced widespread discrimination in the exact way that the law attempts to correct for. Take the property tax exemption in Shevin, because we've already talked about it. It applied to widows but not widowers, and it was upheld even though it was expressly and facially gendered because it purported to remedy past economic disparities of women relative to men. Here's a big underlying assumption. The law assumes that the appropriate time to remedy the economic disparity suffered by a woman was after her husband's death. What if a woman wasn't married but still suffered gross economic inequalities in her lifetime? Well, in that case, the law isn't triggered. It doesn't help the woman in that situation. What if a wife, not her husband, brought in most of the marital assets? In that case, if her husband died, while it might be personally upsetting, it doesn't impact her finances the same way that it might impact his if she had died. Also, is a $500 property tax exemption really enough to remedy a lifetime of economic disparity? You see the point, though. Lawmakers make assumptions all the time, and in the context of drafting a gendered statute, inadvertently or not, it's going to be difficult to not make some of those assumptions based on stereotypes. For example, the stereotype that a woman must fall on hard times when her husband dies, or a stereotype that a single unmarried woman is not in need of the same legal protection to address economic disparity as her married counterpart, or the stereotype that a wife could never possibly be contemplated as making as much or more than her spouse. Does the court give an A-OK to government objectives based in stereotypes so long as the resulting law helps some women? Is that okay? Conversely, if the government passes a law meant to achieve one thing, and the law inadvertently ends up achieving some beneficial, remedial effect that helps women, and the government cites to this second remedial effect post hoc in litigation, is that law okay to withstand intermediate scrutiny? I don't have the answers to these questions. They make my brain hurt. I started this discussion by saying that Ginsburg is all over the place, and she is if you're looking at a traditional application of intermediate scrutiny. What Ginsburg is doing is cleverly using language to up the ante of intermediate scrutiny while packaging it as the same traditional test. She deliberately pushes the envelope of intermediate scrutiny, giving it more bite than we've seen in previous Supreme Court cases that dealt with sex-based classifications and alleged discrimination. And she got 6 other justices to sign off on this expanded version of intermediate scrutiny. Let's shift back to Scalia because he is not happy about this. He starts his discussion on scrutiny by saying, look, intermediate scrutiny is a term made up by the judiciary and doesn't mean anything on its own, which is true. But then he goes on to toss out this nugget. We have no established criterion for intermediate scrutiny either, but essentially we apply it when it seems like a good idea to load the dice. This is less true, as the court does have established precedent as to when applying a heightened level of review is appropriate. In other words, there are times when a blind deference to Congress just doesn't seem like the right thing for the court to do. For example, in cases like this one where there is alleged sex-based discrimination. By casting intermediate scrutiny as a judge-made abstract test, Scalia is teeing up his view that the function of this court is to preserve our society's values regarding, among other things, equal protection, not to revise them. What is masterful about this rhetoric and what makes it particularly damaging is that it forecloses the possibility of expanding the rights and liberties of any particular group, including women, in the name of upholding judicial integrity. Let me take a step back and explain. The Constitution divides the government into three branches: the legislative, executive, and judiciary. The legislature writes laws, the executive enforces laws, and the judiciary interprets laws, resolving any confusion so laws can be better enforced. What the judiciary, including the Supreme Court, is allowed to do is interpret the laws. The court can't create laws because that's Congress's job. And what Scalia's doing is pulling a sneaky. He's saying that in expanding the definition of equal protection in treating government rationale as circumspect when it comes to things like sex-based classifications, calling the government out as discriminating under the pretext of doing something good, that's creating laws, not interpreting them. He's wrong, factually. If the Supreme Court wants to expand their interpretation of the 14th Amendment's Equal Protection Clause, they can. That is an intellectual reframing of doctrine, not a rewriting of the Constitution, which can only be done by congressional amendment, and Scalia knows this. What he's actually doing by asserting that the court is overstepping their constitutionally mandated grounds is sidestepping having to out and out say he doesn't think women or other marginalized groups deserve equal rights. This is the "I wish I could do something, but my hands are tied" argument. It's a blink and you miss it moment that betrays the slant that he's viewing this case through. And if you think I'm reading too much into a single sentence, take a look at this quote. The court favors current notions so fixedly that it is willing to write them into the Constitution of the United States by application of custom-built tests. This is not the interpretation of a constitution, but the creation of one. Custom-built tests here referring to intermediate scrutiny generally, and Ginsburg's interpretation of it in particular. And while 2 data points might be a coincidence, 3 makes a pattern, so let's take a look, shall we? The enemies of single-sex education have won by persuading only 7 justices that their view of the world is enshrined in the Constitution. Why is he being so salty here? Outside of an obvious explanation of conservative values, he's very much reacting to Ginsburg's majority opinion. He notes that she uses the phrase exceedingly persuasive justification 9 separate times in the opinion. Remember, in intermediate scrutiny as traditionally applied, the court is supposed to be looking for a justification or an objective that is substantially related to the means chosen to accomplish it. That sounds like a lower bar than what Ginsburg is setting here, and Scalia is in full revolt. Not only was the test incorrectly applied, he argues, but we shouldn't even be using intermediate scrutiny at all. Sex-based classifications should be reviewed under the more deferential standard of rational basis review, where a law will be upheld if Congress can proffer a mere reasonable justification for why it enacted the law in the first place. Now, it's rare under rational basis review for the court to find a law that is either so facially or blatantly discriminatory as to invalidate it. Applying rational basis review to cases that present issues of sex-based discrimination will have the real-life consequence of continued sex-based discrimination. Scalia says this lower standard of review is warranted because from the nation's founding until the 1970s, read the women's rights movement, that was the standard of review applied to such sex-based classification claims. And to revert back to rational basis review is simply to follow the force of stare decisis, which is a fancy Latin way of saying that the court follows what it has traditionally followed in the past. They don't like making up new rules. I'm not going to get into how problematic that is beyond saying that just because history happened doesn't mean that the degree of progress possible is dictated by an arbitrary date in the past. I know that we're spending a lot of time on scrutiny and the lenses that the justices write through, but it is absolutely crucial to this case. But having talked about it, let's move on to part 2, application of intermediate scrutiny to the facts, aka the judgment itself. The lower courts strongly considered whether single-sex education offered benefits over coeducation, and it featured prominently in their decisions. Ginsburg, on the other hand, spends all of one sentence on it.
Single-sex education affords pedagogical benefits to at least some students.
This sounds like a concession until you realize how much couching there is. Single-sex education benefits at least some students. I mean, yeah. You could use this argument about pretty much anything and it be accurate. Hallucinogenic drugs afford some benefits to some users. I mean, others can see their skin melt into the couch, but some people somewhere derive some benefit from it. It's basically a truism that Ginsburg uses to take a fiercely argued point on the record and dismiss it, while at the same time acknowledging it in her majority opinion. The power of good rhetoric, I'm telling you. Scalia takes the totally opposite approach. For him, the majority opinion presents a very real risk of the extinction of single-sex education. He starts by criticizing Ginsburg's opinion on this point by writing,
As to history, it counts for nothing the long tradition of men's military colleges supported by both states and the federal government. He continues by noting that the tradition of male-only military colleges stems from the tradition of sending only men into military combat, which, yes, does reinforce gender stereotypes even as it accurately presents the nation's history.
The big problem with this argument was that as of 1996, the U.S. military had already begun accepting women into its ranks, and VMI's peer institutions like West Point in New York and the Citadel in South Carolina had already become co-ed. For Scalia, the fact that VMI's peer institutions were co-ed was not the point. The point was that men's military colleges were part of the storied and long tradition of the U.S.,
which was now being besmirched as bygone days of fixed notions concerning women's education.
Where Ginsburg dismisses most of District Court Judge Kaiser's findings, Scalia gives it a lot of airtime, particularly with regard to Kaiser's remarks of single-sex education. But why does this matter? It matters because this is the point of divergence between the way that Ginsburg frames the issue of the case and the way that Scalia does. Ginsburg praises the adversative model repeatedly throughout the decision, and in so doing is able to persuasively argue that women are being excluded from this unique educational offering by VMI's single-sex admissions policy. That's why she doesn't address single-sex education beyond one sentence, because the VMI experience is not defined by its all-male environment. The collegiate identity is the adversative model, which, remember, is VMI's trademark military-style training. Scalia frames the single-sex admissions policy not as a barrier to a unique educational offering, but instead as a necessary tool to uphold a larger tradition of men's military colleges. That VMI has an adversative model is incidental to VMI's mission of producing wartime-ready citizen soldiers. And that's why he spends so much time talking about single-sex education, because he's framing the state interest as allowing men the opportunity to partake in the tradition of going to an all-male military college. This is a thin but crucial line of divergence. Both Ginsburg and Scalia recognize that VMI offers a unique curriculum in Virginia's educational landscape, and that the diversity of educational theories that a state offers to its citizens through state-sponsored colleges is an important and legitimate government objective. The difference is that Ginsburg sees VMI's claim to fame, the reason for its diversity, as the adversative model. For Scalia, VMI's claim to fame, its hallmark of diversity, is that it's the only men's military college in the state, and it happens to have a particularly rigorous adversative model attached to it. To be clear, Scalia doesn't downplay the adversative model, but he does see it as inexorably linked to the male-only experience, where Ginsburg severs these two ideas from each other. And it is because Ginsburg is able to A, separate the adversative model from the single-sex educational experience, and B, frames VMI's uniqueness in terms of the adversative model, that she is able to convince a majority that Virginia did not provide exceedingly persuasive justification for excluding women, thereby failing intermediate scrutiny. The alleged remedy of creating a parallel, separate program, VWIL, was so unequal, she continues, so as to not cure the constitutional violation. And the question is, how did she get there? Reading this opinion is like watching an episode of WWE SmackDown. You have to have your popcorn at the ready. Virginia tries to argue what Scalia does, that the all-male admissions policy and the subsequent all-male experience was justified as adding diversity to the state's educational landscape. And Ginsburg shreds it. Oh, she says, Virginia, are you sure that your single-sex admissions policy was a concerted effort to diversify your state's educational offerings? Because history shows you lyin'. When VMI was first founded, educating women was akin to inviting the boogeyman into your home. It was considered dangerous, and you just didn't do it.
If women were admitted, it was feared that they would encroach on the rights of men. There would be new problems of government, perhaps scandals. Standards would be lowered, and the glorious reputation of the university as a school for men would be trailed in the dust.
VMI's admissions policy isn't vestigial. It isn't the case that it survived by chance to present day as a historical anomaly. It was a deliberate and concerted effort to exclude women even when other comparable institutions of higher learning like the University of Virginia became co-ed. Scalia responds to this argument by basically saying, nuh-uh, back to Ginsburg.
She points out that in 1982, when the Supreme Court decided Mississippi University for Women v. Hogan, VMI actually re-examined whether there was a legitimate basis for maintaining its all-male admissions policy. A mission study committee studied the issue for almost 3 years and decided against changing their admission policy, citing the anticipated difficulties in attracting females to VMI while providing very little indication of how the conclusion was reached. Ginsburg doesn't find this sufficient to withstand intermediate scrutiny.
Personally, I don't know what they were doing for 3 years if at the end of it they didn't have a comprehensive reason for continuing an exclusionary policy, particularly if they had the foresight to consider that they might be dragged into litigation over the exact same policy. But that's just me. Scalia points to the same mission study committee and says that by virtue of creating it and the time spent analyzing the problem, that regardless of sort of the robustness of the findings, that alone imputed a legitimate government interest for continuing to exclude women from the school.
More than that, it utterly refutes the claim that VMI has elected to maintain its all-male student body composition for some misogynistic reason. This is some dangerous bullshit, and it's bad logic. He's using a de facto if-then construction here. If X happens, then it means Y. For example, if it rains when I'm outside and I don't have an umbrella, then I get wet. It's a rhetorical method of expressing a logical conclusion, an eventuality of what must happen if certain things occur. Obviously, if I don't have an umbrella and I'm standing outside when it's raining, I'm gonna get wet. Duh. The problem is Scalia is trying to get us to that duh moment when the logic doesn't follow. Here's what he's saying pared down. If VMI examined its single-sex admissions policy and chose to uphold it, then the policy must not be misogynistic. The problem is that this isn't the only logical outcome. One of the proffered explanations for not changing the admission policy was that VMI would have a hard time attracting women, and that itself is grounded in misogynistic stereotypes that women as a gender would not want to attend a military college and be trained to be the citizen soldiers that VMI is famed for producing.
There could be a whole host of reasons why VMI decided to uphold its single-sex admissions policy, but they don't really say in the report, and so we don't really know, and that's why Ginsburg says that it's insufficient. But the fact that Scalia says that the process of reviewing the admissions policy alone utterly refutes any misogynistic underpinnings is not just logically bankrupt, it's dangerous. That kind of logic justifies performative actions by those in power as sufficient in addressing concerns of discrimination, and offers those same power brokers unqualified immunity from discriminatory practices, even if the end result is nothing changing. I want to make the point here that in the case of VMI, there is no doubt that misogyny was woven into the single-sex admissions policy. There's strong evidence in the record. I did talk about it in my last video, and I want to bring to your attention an open letter written to the VMI alumni community in 1996, shortly after this decision was published, by a woman named Phyllis Schlafly, who was on the board of VMI, and she was a very prominent conservative.
She expressed her view that VMI should go private to maintain its all-male admissions policy, writing, "If you allow Ginsburg to do to VMI what Pat Schroeder has done to the United States Navy, you are not the exemplars of manhood we thought you were. I mean, how pervasive and entrenched does a stereotypical culture of machismo have to be in order for this to be a persuasive and non-ironic call to action, I ask you?" And I want to pause here, lest you think I'm making a mountain out of a molehill, to read a couple more quotes from this open letter. "The radical feminists just can't stand it that any institution in America is permitted to motivate and train real men to manifest the uniquely masculine attributes. You need to understand that the lawsuit against VMI had nothing to do with securing opportunities or benefits for women. It only had to do with destroying the masculine integrity of VMI. The feminists hate you just because you exist. Don't make the mistake of changing VMI's unique lifestyle to try to accommodate sister rats. The women who seek a military career based on dual standards and gender norming can go to West Point, Annapolis, or the Air Force Academy." That'll be a big yikes from me. Back to the majority opinion.
Ginsburg pushes back on gender stereotypes and calls out the history of gender discrimination over and over in her opinion, and she supports it with evidence. Scalia does his best to cast these same points as an isolated minority view, as an indicia of the age that has no real staying power, as if the fight for gender equality was a flash in the pan to be endured before the world reverted to the way it was before all this unseemly feminist noise. And then he says this:
"It's hard to consider women a discrete and insular minority, unable to employ the political processes ordinarily to be relied upon when they constitute a majority of the electorate, and the suggestion that they are incapable of exerting that political power smacks of the same paternalism that the court so roundly condemns." We have to talk about how problematic this rhetoric is, because it was written in 1996, and 25 years later, in 2021, it's still used to dismiss the systemic oppression of women, LGBTQIA+, and BIPOC communities. Scalia isn't the first person to use this logic, nor is he the first person to codify it in writing, far from it, but he did use it even in the face of evidence to the contrary, which shows a distinct pattern of historic discrimination against women. So we're going to break it down. This first sentence is a by-the-numbers argument. Depending on the year, women make up around 51 to 52% of the population, so Scalia argues that this means they cannot be considered a minority as a matter of fact. This argument fails because it does not take into consideration the myriad ways in which society is structured and culturally operates to denigrate and exclude women on a daily and generational basis from equal access to opportunities, education, advancement, power, and a whole lot more. This is doubly true for women of color, women with disabilities, women who identify as LBGT, and basically any woman who isn't a cisgendered white woman. If you don't know what a cisgendered white woman looks like, may I present Exhibit A. So here, when Scalia writes this second sentence, he is missing, deliberately or otherwise, the crucial fact that even if some privileged women are able to take advantage of the political process, that same political process and the political power that comes with it are designed to be exclusionary at worst and obstructionist at best for women as a voting bloc. And recognizing that there is an accessibility gap in the political process between women and men isn't paternalism, it's a step towards equality. This is the same logic that produces the pull yourself up by the bootstraps argument, as if we live in an actual and true meritocracy, which we don't. We live in a society that is
socially, culturally, and economically lopsided and plays favorites. And this logic, surprising 0 people in the advocacy community, exists and persists to this very day. It's being used at the Supreme Court level presently in a case about voter restrictions that are designed to stop the impact of minority voters. That case is Brenovich v. DNC. Listen to what the attorney defending voter restriction laws had to say.
Because it puts us at a competitive disadvantage relative to Democrats. Politics is a zero-sum game.
To be clear, I am in no way trying to equate the experiences of the BIPOC community with that of women. They're not the same. What I am trying to point out is that the same logic that Scalia used in this decision in 1996 exists today and is not just used against women, but is repackaged and used also against minority communities. So look out for this argument. It's around us all the time, it's pervasive, it's in the news, and it's in American jurisprudence, and you can for sure see it in Scalia's dissent. Back to U.S. v. Virginia. Ginsburg notes that even at the start of litigation, 6 years before the case ever was heard before the Supreme Court, it was acknowledged that there were some women who would love to attend VMI if given the opportunity, and that there were some women who would be able to meet all of the physical demands placed on VMI cadets. Given that these two facts were undisputed at the start of the litigation and were never disputed even as the case moved forward through the appeals process and ultimately landed before the Supreme Court, VMI can't actually, with any sort of leg to stand on, say that its adversative model is fundamentally unsuited to women. Sure, most women would not choose to be educated according to the adversative model, but neither, Ginsburg points out, would most men.
But assuming that there may not be a wave of female applicants is not the issue. No one is forcing women to apply to VMI, just like no one is forcing men to apply to VMI. The issue instead is whether the state can constitutionally deny to women who have the will and capacity the training and attendant opportunities that VMI uniquely affords. Allowing female applicants through the gates of VMI will not damage the school stature, destroy the adversative model, or bring fire and brimstone down upon the heads of those who do or will later attend the institution. Ginsburg next turns her attention to the inadequacies of VWIL as VMI's remedial plan, following much of the government's argument that I touched on in my last video. What Ginsburg also does is point out the harmful gender stereotypes that are lurking behind both Virginia's arguments and VMI's all-male admissions policy. First is the idea that VMI's adversative model will be unsuited and not effective for women as a group. Generalizations about the way women are, estimates of what is appropriate for most women, no longer justify denying opportunity to women whose talent and capacity place them outside the average description. And then there's the flip side of the coin. Virginia never makes the argument that VMI is unsuited for most men, and the idea that the purpose of VMI is to funnel cadets into career military service as another reason why women should be denied entry also falls flat, because as it currently stands, neither do most men who attend VMI. Only 15% of cadets enter career military service. The overt stereotypical attitudes of what women can do or would want to do, coupled with the utter failure of VWIL to be in any way equal to VMI, are fatal to Virginia's case. The result is that the Supreme Court held that women would no longer be denied admission to VMI. I want to end with a quote that closes Justice Ginsburg's majority opinion, not just because it's a mic drop moment, which it is, but it's a reminder, I think, of the power of legal advocacy to help in a very concrete way to address real-world discrimination. A prime part of our history of the Constitution is the story of the extension of constitutional rights and protections to people once ignored or excluded. VMI's story continued as our comprehension of we the people expanded. There is no reason to believe that the admission of women capable of all the activities required of VMI cadets would destroy the Institute rather than enhance its capacity to serve the more perfect union.